A second thing that we are in dire need of discussing is this matter involving the justice nominee proceedings, and that there's been a lot of criticisms, and a lot of it, quite frankly, is valid. But I want to address some of the ones because I've been talking about it on my TikTok channel, discussing it, that the criticisms that I have seen are like some of the responses that I've seen, the feedback that I've seen, and whether or not they're valid criticisms. And so let's start off with, why is it so hostile? I think at some point we kind of need to grow up as a society and realize that nothing that happens in government, politics, involving any kinds of, let's say, civil rights or justice nominations, checks and balances, any of these kinds of matters, is ever going to be anything other than hostile. You have opponents, like, it's like, why are people, like, no one would criticize a UFC fight for being too hostile, for being too conflicting, that why are these two men in there, why are they trying to hurt each other? Like, that doesn't make sense. But that's exactly what politics is. It's literally two warring camps fighting in non-military terms. Like, that's what it is. And so when we saw the previous justice nomination processes under the previous presidential administration, they were heavily contested, highly conflictive, highly hostile, and of course the same is true this time. And it will be that way forever. If you watch footage of parliamentary proceedings in in the UK, or you watch movies, dramatized films and things about Winston Churchill or Franklin Delano Roosevelt or JFK or any of these, you will find hostile conflicts all the time. That's the way it is intended to function. Anytime you see both sides or all the different sides of an issue locking arms in a singular direction, you should actually be worried about that, because there aren't very many things that these sides agree about. So that's the first thing. Number two is that the questions that the people were asking the nominee were unfair, loaded, or trap questions. And to that I would respond is the reason that we are given, or maybe we should say enshrined, we have enshrined the right to remain silent in the Constitution, the Fifth Amendment, in regards to questioning when you're with law enforcement or any kind of government officials, or the decline to answer, the refuse to comment, any of that kind of thing. The reason that's there is specifically because anytime you are in a conversation or a confrontation with law enforcement or with Congress, a judge, it is always a trap. That's why you have the court reporter, the stenographer there, writing down word for word everything that is said in a grand jury or in a court proceedings or and so forth. Like, the reason those things are there is so you can have precise, detailed wording of everything a person has said, to be able to read that back to catch someone if you can indeed catch them in something. That's why that's happening. And that's why one of the main things that you'll hear in any kind of proceedings like this is that you do not speak to law enforcement or anyone, the DA or whatever. You do not speak to them without your lawyer present to intervene, supervise questioning, or your legal guardian or your whoever, because if somebody says the wrong thing, even by accident, it can cause you a whole slew of problems, and they will try to catch you. That's why they say, they Mirandize you when they're putting the bracelets on you, saying that anything you say can and will be used against you, not for you, not with you, against you in the court of law. It's always a trap. Anytime you're speaking to someone who's got a badge on, has a prefix of any kind, it's always a trap. So the next thing would be, what about her response? What was this questioning? Well, let's talk about the question first. What was this question? And the question being regarding, can you give a definition for what a woman is? What was this question attempting to produce, or the purpose of it? And quite simply, the purpose of that question was to get a bearing on the nominee's potential posture or position or likely ruling judgment in the event that a case was brought before the court regarding the issue of the definition of womanhood, trans rights, any of those matters in the near future, or at any time in the future, because judges are presiding for their entire life. They wanted to get a thermometer reading of where she stood on the matter. And in that matter of, they're trying to determine whether or not to confirm her for the Supreme Court. That is a valid question. That is a valid line of questioning for people that are interested in knowing what the checks and balances are going to look like in the future. So, what about her response? She said that, no, I can't because I'm not a biologist. And so, first off, that is not how that works. For a lot of people are saying that she shouldn't be ruling in, or shouldn't be deciding in accordance with her opinion, that she should, let's say, delegate or respond to delegation from experts in field or testimony or so forth on the matter. And here's what I would have to say to that. Number one, opinions are precisely what you pay justices for, or that you appoint justices for, that you pay them the money that they receive, whatever that is. Their salary is worth their opinion. In fact, when they rule on the matter of an entertained case, it's called an opinion. There's the majority opinion if it's a split court, or the presiding opinion or the deciding opinion. And then if there is a dissenting opinion, that they'll also write that as well. And that each individual justice in the court will write either an affirming opinion, adding additional insight of their own mindset to the ruling, or a dissenting opinion on their own individual stance of why they chose to count their vote in the way that they did. That is what these justices are supposed to do. So when you impanel, or when a lawyer or some sort of litigant argues in the court about the issue, they will call various expert witnesses and so forth to argue, but both sides are going to have their own sets of experts that will argue from their own points of view, and then the judge is expected to rule within the scope of the law according to what their discernment individually, their individual opinion tells them is the right decision. That's what a judge does. So being upset about the idea of a judge having opinions is completely a misunderstanding or distortion of what the court does. Number two about this matter is that by saying I'm not a biologist, therefore I'm not qualified to render a definition of womanhood, is extremely problematic, because it assumes that only an elite, educated, articulate aristocracy comprising of experts, which is an undefined term here, but I guess we can understand what it means colloquially, of experts are the only people entitled to have a trustworthy opinion about anything. That's dangerous. It's anti-democratic to suggest that only a select, minute few, given basically tissue paper diplomas, are allowed to have opinions. That's anti-American as well, that simply this is not what our system was designed to be like. That in fact everyone is supposed to be entitled to their own opinion, right or wrong, and that yes, it is important to have experts on hand that can grant additional insight, but you as an individual still have the right to agree or disagree. That's important. And that even if in the imaginary world where only experts are allowed to have opinions, then what is the purpose of the court to begin with? Just go to the expert, and the expert can then rule unilaterally according to their opinion or their perspective or their experience instead. Number 3 about this matter is the fact that woman is a constitutionally, a legally protected class of individuals, which is, like for instance, in the 19th Amendment regarding women's right to vote. The class of individuals legally granted the right to vote called woman. So the court has already recognized a functional, at the very least, colloquially maybe, definition of what womanhood is. And therefore, she, as a justice of the court, is expected to rule in her decision making, or according to her discernment, and supposed to rule in the light of that established precedent until a new ruling is provided in response to a new case which in some way alters that established precedent. That's the way it works. That she is supposed to defer back to the previous established definition until a new one is provided. So in this instance, she should have said, well, the court has viewed it this way or that way in the past, and in the event of a new court case, we can re-examine it. That would be a better answer. Which, continuing on from the way she responded, saying, I can't because I'm not a biologist. Here's the deal. She actually gravely undermined the very people she was attempting to appease with that response by suggesting that the definition of womanhood is rooted in the insight a biologist would have apart from, let's say, a philosopher, a psychologist, a psychiatrist, or a gender studies major, or something along that line. She could have appealed to any classification of expert, quote unquote, in that instance, but she chose biologist. Maybe that was on, let's say, like she was put on the spot with it. Maybe she had prepared that. It's unknown, quite frankly. But the fact that she chose to root it in biology is gratuitously, let's say, condemning of the trans movement, because it suggests that womanhood and by proxy manhood are both primarily rooted in physical being, not in emotional state or psychology or any other thing that could possibly be appointed towards in today's society in order to attempt to change that definition. That's really critical, that it's supposed to sound like that she's siding with this liberal leftist movement, but in fact, actually, she gravely eroded that with her statement. So it's all really important to note that she actually didn't do what she thought she was doing, and that additionally she did precisely the thing that those conservative interlocutors were wanting her to do. She fell right into their trap rather than circumventing it in the way that many of the leftist liberal are trying to spin it as she had done. So it's really critical. We are looking into the future, being that I think the last thing, maybe the most significant thing, I've said that a bunch of times, but maybe the most significant thing is what she has said by default here, is that if you can get an expert to say whatever you want that expert to say and get her to sit and hear that expert speak, that she will default to the opinion of whatever an expert tells her to default to. And that's a dangerous position for the court, but at least it's clear enough. We understand that it's always going to reside, as far as her judgment, is if what she's saying is completely accurate, that her judgment is going to be primarily reliant upon whatever the expert testimony and its persuasiveness happens to be. So if whatever side has the more persuasive, charismatic individual on the stand, that's going to be the winner for her vote in the eventual case resolution. And that could obviously be a double-edged sword, but it just puts more emphasis on the importance of who the witnesses are and who the litigants end up having to be. So there's a lot to take in there, but I think it's all really important for us to know.